lunch.
Excuse me, is it possible for you to speak louder?
I will try.
Thank you.
So, the first part of it is we'll discuss what the principles are that govern the state's liability for highway snow and ice conditions. And we'll try to extract from that the principles that govern that issue, because if we're going to be talking about changes in operational practices, we'd like to know if we can have an educated guess or some type of predictive estimate as to how that operational practice may or may not affect the state's potential liability for these types of accidents. And secondly, we'll talk in the second part about special state legislation that the state legislature has passed that particularly protects municipalities from these types of highway accident claims, but which legislation has not been passed to protect the state itself. So let's talk first about the court-derived principles. I got to keep coming back to this. I'm sort of used to dealing with a remote clicker, so I want to focus on, and by the way, when you see something in quotes here, it means that it's a direct quote from a court decision. And if you go to the website for the conference, you'll see I have a 17-page handout which further gives more details about these principles and gives reference sources for all the principles that are asserted there. So those are case citations. Now, I don't expect you to go and read the cases, but as a follow-up to this conference, you may be consulting with certainly counsel. Legal counsel will be part of any group that is analyzing the changes in practices you might be considering and how that might affect the liability. And so your legal counsel will have the references readily available for him. I also have an appendix as part of that presentation, which is on the website. The appendix collects some cases that we're going to talk about today, the full text decisions of those cases. It also collects some hard-to-get materials in this area that might be convenient for you. So, reasonably safe condition for travel. Well, that's a buzzword that gets repeated over and over again. It's meant to convey the idea that the state or a municipality is not a guarantor of the safety of the road. We have to do what's reasonably possible in order to create a reasonably safe highway for travel. And the way the courts measure that is by using the word negligent. The word negligent and reasonably safe are just two sides of the same coin. If you are negligent, it means you did not maintain the highway in a reasonably safe manner. And so in the tort system in New York State, it's what we call a negligence-based system, but it's also a fault-based system. So the courts require the injured party to show that, in this case, the state is somehow at fault, and the courts equate fault in this setting with negligence, namely not maintaining the highway in a reasonably safe condition for anticipated traffic. Now, you might ask, well, negligence is sort of a technical term. What do you mean by negligence? It's a court-defined principle. The legislature has not defined negligence. It's strictly the purview of the courts. And this is what the definition is. What a reasonably prudent person would do under the same circumstances. Now, in our system, usually juries determine that. You know, juries second guess people all the time. You get into a car accident, juries will say, well, this driver didn't act properly. He acted in a negligent manner. But when we're talking about the state, we have to change our thinking a little, because the state legislature has not permitted juries to evaluate whether the state is negligent. When the legislature created the court in which the state is sued, which is the Court of Claims, it's a special court, they prohibited juries. They made the judge, in effect, the jury. Now, that has some advantages for us, frankly, because when a jury is asked, in a case, whether somebody was negligent or not, they just give a yes or no answer. You know, the foreman stands up and, yes, we find the defendant negligent. Well, that doesn't really tell us too much. We don't know what arguments were persuasive to them. We don't know what evidence they may have found compelling. We don't know their thought process and reasoning. We just get a yes or a no. But because judges in the court of claims against the state sit as juries, these judges render very detailed written opinions about the facts in the case and why they think the state reasonably maintained the road or not reasonably maintained. So this helps us immensely in being able to predict outcomes of cases, because as we'll see, the principles are very well established because of this explanation on a daily and monthly basis of what their thinking is. And it enables us to craft our strategies and get a pretty good idea of where the court of claims judges are. It's a relatively small court. There's only 40 to 50 judges. They meet a lot. They read each other's opinions a lot. Their opinions are on their website, at least for the past 15 years. They're publicly available now. They weren't publicly available before 2000. And they basically are on the same page 90% of the time when it comes to agreeing on the relevant legal principles. Of course, when you get into a particular case, it gets very fact-specific, and you can't compare apples and oranges. But they generally are on the same page, and there's very little disagreement on the legal principles that govern the underlying liability. So this is a direct quote from the Court of Appeals of our state, which is the highest court. It's the golden rule, so to speak. And the first key word there is sound discretion. It may not sound like a lot, but it's very important in the law when a court recognizes that a public official has discretion. It makes the court much more hesitant to second guess a decision about how to safety. And of course, the second part we see reasonably safe for people who obey the rules of the road. So now we got another factor, so to speak. The driver's behavior is also relevant to this equation, right? I mean, we're going to be talking mostly about the state's obligations, but let's not forget that an operator of a motor vehicle also has an obligation to ascertain the conditions of the highway he's on and to operate his vehicle appropriately. And there are situations where the operator's conduct is so egregious that the case will be dismissed, no matter how we view whether the state reasonably maintained the road or not. You know, examples are excessive speed for the conditions prevailing. You know, being impaired with intoxication, drugs, or alcohol. You know, so those types of things up. So the courts aren't blind to the fact that this is not a one-sided evaluation in terms of deciding who might be responsible for the injury. Okay. So this is another direct quote of the courts. Now they're using this word reasonable diligence. The question is whether the state exercised reasonable diligence to cure the situation. Well, don't get too hung up on reasonable diligence. It's the same thing as acting to make the highway reasonably safe. It's the same concept of acting in a non-negligent manner. Courts sometimes try to define phrases, and when they define the phrases, they just use synonyms. They don't really tell you too much more about what they're trying to define. This is one of the areas, and they say, well, the state will reasonably maintain the highway in a safe condition for travel if it acts with reasonable diligence. And this is what another court has phrased it as, whether ice is present on the road as a result of a lack of reasonable care or in spite of it. Namely, the courts recognize the state can act in a reasonably diligent manner in dealing with the snow and ice control event. And nonetheless, you're still going to have snow and ice on the road. So the fact that there's ice on the road doesn't satisfy the claimant's burden. Right? If the state acted in a reasonably diligent manner, the fact that there's ice on the road that caused the accident doesn't equal state liability. The test is whether the state acted diligently, not whether after the diligence was exercised, ice existed. Because ice is always going to exist in upstate New York on highways, no matter what kind of plowing or deep routes you have and how frequently you do them. The other hurdle that a plaintiff has to overcome is the concept of notice. And this is a court-developed doctrine. They require notice in some fashion before an injured party can recover. This would be notice of the dangerous condition, be an ice condition or some type of a snow condition. And the courts developed the idea that actual notice obviously means that the highway officials know about the condition. They actually see it with their own eyes or they get. But the courts have also expanded that to the idea of what they call constructive notice, which is a legal fiction, but the courts nonetheless employ it to say that if the condition existed for a sufficient period of time, that a reasonable person would have discovered the condition, then we're going to assume that you had notice of it and evaluate what type of response you had to the condition. Well, as you may be aware of living in upstate New York, ice can form very, very quickly. You could get, blowing winds that have wind chills that suddenly decrease temperature. So the fact that the ice is there and causes an accident is not dispositive. The injured party has to show something more. Namely, he's got to show that he actually knew about it, that the state forces actually knew about it, or that it was there for such a sufficient period of time that the state should have known about it. Now, what's a sufficient period of time? Well, see, that becomes a question of fact for the judge to decide the case. There's no magic number of 30 minutes, 60 minutes, 90 minutes. We do know that recurrent or hazardous conditions in a specific area can easily lead to the court finding notice. These are situations, for example, where you get overhanging trees that block sunlight from a portion of the road. Sunlight would normally create, the melting of the ice in other parts of the road, but this part of the road, the tree pattern and cover makes it very shady. So if the highway officials know that it's a recurring condition, the courts are more likely to say, well, we should have known that that was going to develop. It happens every time during this, during summer removal season. Or if you have rock very near a road, and the rock is moisture laden and tends to spill water onto a highway and the tree freezes. Those are the type of recurrent conditions that the courts are talking about. But if you give those areas the attention, if you maintain those areas and you have a plan to give some special attention to those areas, then it's very possible the court would say, well, you have a plan to deal with those problem areas. You exercise your reasonable diligence, and we're not going to hold you to the status of an insurer or a guarantor that ice will never appear on the highway, even in those areas that tend to be problematic. So notice as a hurdle an injured party has to overcome. It's not the state's burden to disprove, but it's the injured party's burden to prove that the state has some type of notice. And the courts are very practical in this area. I mean, those are direct quotes from court decisions. It sort of shows the mindset of the court when they approach these issues. They're aware of the realities of winter in upstate New York. They're aware that snow and ice can form at any time, even when a good job, a reasonably good job is being done. And so the mindset is a very good mindset when we start out in the course. The good thing for the state is that we have judges that determine these issues. Municipalities have juries, and juries can be very different. I mean, the 6-person jury in Essex County that deals with snow and ice all their life and their drivers is going to look differently at things than a 6-person jury from the Rocks or from Manhattan. So the jury system doesn't give us that predictive value because 6 people from different parts of the state may have different ideas of what's reasonable under the circumstances. At least with the system we have against the state court of claims, the judges, as I said earlier, are pretty much on the same page and adhere to these principles. And this gives us sort of we sort of walk in with a very favorable general attitude. This, combined with what I said earlier, is entrusted to the sound discretion of governmental officials. There is a desire not to second guess in the field type decisions because of the quasi-expert nature that those decisions may entail. And so these are some general principles that come from what I've said before. The mere presence of ice on a highway doesn't mean the state is negligent. So if somebody gets into an accident and says, I lost control because I encountered a patch of ice, and that's all they present to the court, the case will be dismissed. The case will be dismissed. If that's all they can show, is that I was driving on a highway, I encountered ice, I lost control, that definitely will not satisfy that injured party's burden to show negligence. He has to go farther. He has to basically show that there was some defect in the state's plan for maintenance. Now, as a practical matter, when we try these cases, we usually bring in all the evidence. We, having the Attorney General of Defense DOT, we usually bring in all the evidence of why the highway was maintained in the proper manner. We get the snow and ice control tickets, we get the feed information. We show how many times the truck went out and treated that section of highway. We can show this from the records. We can show application rates of whatever they're applying. And so really when we get to court, if we get that far, sometimes we get these dismissed prior to an actual trial. But if we actually get that far, we're usually the one presenting the evidence as to why we reasonably maintain the road. But the plaintiffs, the attorneys are smart enough to know that they just can't come in and say, and put their client on the stand and say, when you testify, I was driving my car, I was driving at speed limit, I encountered ice, I didn't see it, I didn't realize it until I started losing control. And if that's all the evidence they put on, then case dismissed. We don't even get to showing why we didn't do the job on the highway. Now, in addition to these generalized defenses, there are some specialized defenses that apply in the snow and ice context. And one of them is called this storm in progress doctrine. And this is a court-developed doctrine. And if an accident occurs during a storm, and we'll define later what we mean by a storm, then there's no responsibility legally during a storm to make the highway reasonably safe for traffic. Many accidents occur during quote-unquote storms. In those cases, our defense is simple. We just need, it's our burden to prove there was sufficient unique clumsy weather. And a storm, is a vague term, admittedly, but there are certain things, obviously storms, snowfall, certain rain. But courts have always said, you don't need a blizzard. It's just some type of inclement weather. It could be blowing and drifting snow. It could be freezing rain. So until the storm is over, I know that we maintain the highway during the storm. The point here is that the courts say if an accident occurs during the storm, somebody encounters a snow or ice condition on the driving lanes that causes them to lose control, they're not able to sue by reason of that fact alone. And the way the courts phrase it, there's no legal duty to make the highway reasonably safe for travel during the storm. And so that will eliminate a lot of cases right away. And sometimes we fight about whether the weather was inclement enough to be a storm enough, then we might have to go to trial. But a lot of times we can get these cases dismissed prior to trial by bringing in the old weather records to say, Judge, there was continuous snow for 24 hours or 48 hours. Here's the Miller records of hourly snowfall. Here's the documentary proof that there was a storm. This accident occurred, right in the middle of the storm, the beginning of the storm, the end of the storm. But we don't need to show anything more. We don't even need to show that we were reasonably maintaining the road during that time period. The fact that there was this inclement weather is enough for a court to say, yeah, too bad you had the accident, but there's no legal obligation to the state to maintain a reasonably safe road during a storm. The other specialized defense that we have available to us is something called this qualified immunity defense. This is a little more technical and it's a little more difficult to prove. But in 1960, the State Court of Appeals sort of opened the door to this defense for municipalities and for the state. It applies to both. What was bothering the Court of Appeals in 1960 is that, for the previous 170 or 80 years, juries had always determined what was negligent. And the court was bothered by the facts, in that case in 1960, that the jury was second-guessing an expert professional traffic engineer's judgment. It was a case involving a three-color traffic signal and an intersection. And when you go through an intersection on the caution, then the caution turns to red. But the traffic that's being stopped doesn't get to green right away. They have to give time for that vehicle to get through the intersection. So there's some type of judgment as to how many seconds must elapse between when the caution turns to red and when the red turns to green. It's called the clearance interval. Well, the jury found the city of Buffalo didn't have enough time in the clearance interval. And the Court of Appeals was bothered by this because they said, well, wait a minute, how can, what do juries have, are we going to really let juries second guess something like this technical traffic clearance interval stuff? What are they basing their opinion on? They have nothing to say that the expert engineer that fixed it at 3 or 4 seconds was wrong. He should have made it 5 or 6 seconds. So they were sort of bothered by the fact. But they didn't want to totally immunize the governmental decision either. So they came up with this hybrid, middle-of-the-road type of approach, and that's why the word qualified is there. It's not an absolute immunity from suit, but it's qualified. And the qualification arises from the fact that you have to prove that the state's or municipal experts actually studied the problem and made a conscious, deliberative policy decision either to do something or to not do something, or to pick among various options. That's not always the case. Sometimes things just happen in government, and you ask people, well, why do you do this? I don't know, I've been doing it for the past 25 years. And that's it. So it doesn't work all the time because nobody can really give you the proof that, oh yeah, we studied this. We know exactly why we're doing this. Or we know exactly why we're not doing this. And these are the reasons, and this is what went into our thinking. Okay, so for many years, this doctrine was applied only to like infrastructure type developments. Where to put guide rail, where to put median barrier, whether the super elevated curve, how to deal with drainage, all these infrastructure type things. But then the court started saying, well, you know what? There's no reason why it can't apply to operational decisions on how to maintain highways. And in fact, the courts have allowed the state to escape liability altogether if it can show that the ordering of priorities that it made was in reasonable response to the problems that were studied. For example, one of the landmark cases, you had a situation where you had bridge barrier, you had tremendous snowstorm, high accumulations, the plowing, so much snow on the shoulder is going against bridge barrier. The barriers become totally impacted. They lose their function because snow is in front of them. They can't prevent a vehicle from leaving the road. And if the conditions are just right, that snow can actually become a ramp and a car can careen over it down, so-called vaulting accidents. Well, if you read the New York State Snow and Ice Control Guidelines, the removal of snow from bridge barrier was consciously determined to be a post-storm cleanup activity. And they had listed their priorities. You keep the main line clear first, then you push snow off your shoulders, then you get to gore areas, then you get to intersections. And these are the areas you make safe for traveling. And then you get to things like removal of snow from barriers. And in the case that was involved in the injured party said, look, you should have gotten to this bridge barrier earlier. And the state's defense was, we studied the issue. The kind of accident you're talking about is very rare, number one. If we divert resources from keeping the main line clear, we're going to create more danger for more people because they're using the main line. So we made a conscious decision to allocate our resources to first keep the main line clear, then push back at shoulders, then go to gore areas, intersections, etc. So the court said, yeah, I'm not going to second guess that expert decision because the DOT actually formed a committee to look at those things in the early 90s, was aware of the risk of vaulting over snow impacted barriers, but considered the risk in relation to the risk that would be imposed on other people if they diverted resources to the bridge barriers. And made conscious decisions that we're going to protect the greater amount of people who are using the main line, and we'll leave this to post-storm cleanup. The court said, I'm not going to second guess that. I have, case dismissed. I recognize that there's a hands-off discretionary judgment here, and I'm not going to second guess it. So that defense is available to us anytime that any governmental agency can show that they studied the issue, considered risks, and have a plan of attack on how to deal with the risks. Doesn't make any difference if the plan of attack can be second-guessed later. To say, well, gee, if you did it differently, maybe this accident wouldn't happen. Doesn't make any difference. There's more than one reasonable response sometimes to a dangerous condition. And as long as the response chosen or the path chosen is reasonable, and I know we're back to this word reasonable again, but that's what the court's saying. Remember I told you it's a qualified immunity. They don't want to get absolute immunity. So they always hang back a little and say, 99% of the time we're going to give the benefit of the doubt, but we always reserve the right to say that whatever you did was just totally out of the reasonable area. It was just totally bizarre, the decision to just didn't make any sense. But that's a very rare exception. I'd say 99 times out of 100, we are successful. The only time we're not successful with this defense is if we don't show that we adequately studied the issue. You know, like you ask somebody, well, why are you doing this? Nobody can give you a reason. Nobody can enunciate a rationale. Nobody can give you, you know, well, we all sat down and, you know, we considered the pros and the cons, and this is what we can. If none of that can be shown, then that's where we lose this. But once we get over that hump of showing that we studied it, 99 times out of 100, courts say, I'm deferring to your judgment. I'm not going to second guess the policy or resource allocations that you make. Well, let's talk specifically in that, you know, talking these abstract principles. If you go online, you'll see that I have this case online in my printed materials, and you can read the actual decision. I'm just summarizing it here. But this was a case where a car encountered a patch of ice, and he claimed that DOT was negligent because they didn't use enough salt to treat the highway. DOT, and this was in Erie County, was using a mixture. This case is from 1986. Okay, this is an older case. And so, you know, that was essentially the plaintiff's claim. And the court dismissed the case for essentially two reasons. One, the court first looked at what we talked about earlier. Well, what did the state do to reasonably maintain this highway? You know, did the state exercise reasonable diligence in its plan to maintain this road with the snow and ice control event? And if you read the opinion, you'll see that the state had a pretty good plan. This highway was on a beat that was serviced by 5 snowplows on it, 5 runs made. They had the snow and ice control tickets, which are written records of when the truck leaves the maintenance facility, when it gets back, what its load was, what its application rate was, how long it was out, usually the beat number or letter. So, you know, if he was out for 3 hours and the beat normally takes 45 minutes to circle, well, you know, because that's what they do, they keep going around the beat until somebody tells them to stop. So you say, okay, that, you know, based on this business record, this document, I can show he went by this exact spot on this highway 3 times, you know, in 5 hours before the accident, let's say. And so the court first said that was reasonable diligence. And if ice was present on the highway, so what? The state acted reasonably, case dismissed. But the court went further and said, oh, by the way, as an alternative basis for dismissal. And you know, see, you would never give this with a jury case, because the jury would just say yes or no, and you wouldn't know why they decided the case. But the court's decision goes on to say, oh, by the way, even if I didn't find reasonable diligence, I'm looking at the DOT snow and ice control guidelines, and I find in there authority given to the resident engineer for this area to use his discretion to reduce the use of salt and to use abrasives when he thought the conditions warranted it. And I think this particular resident engineer reasonably exercised his discretion. The resident engineer testified at trial as to what the weather conditions were, what the weather conditions were anticipated to be, why he deviated from using more salt, because he didn't think it would be productive. And of course, said, yeah, I'm not going to second guess that decision. So there were 2 reasons why the case was dismissed in a situation where there was a direct attack on the conscious decision to use less salt. So that direct attack didn't work in that case. The other example, another case, if you want to see the facts on this, you can get them online at the conference website, was the Boyd case. And This was a little more sophisticated attack. The injured party's lawyer had, a fairly typical case. The vehicle skids out of control and leaves the travel lanes. And the temperature was about 10 degrees at the time, but the calcium chloride was not being used. Although, if you read the DOT guidelines, it did recommend consideration. It didn't mandate it, but it did recommend consideration of calcium chloride when temperatures were below 20. And so the claim was dismissed. The court finding the state was not negligent in failing to use calcium chloride because the departure from the recommendation was justified in this case because the state's resident engineer, which is their local maintenance supervisor, you might say, testified that in his experience for the terrain and the climate and for the traffic conditions of that particular highway in that particular part of this county, it was not effective. And the court credited his testimony. He says, well, the decision was reasonable. The temperature was dropping because on this particular morning, and there was a real threat that if you use calcium chloride, it would melt it, and then you get a refreeze situation. That was on the mind of the resident engineer. He didn't want to create the potential for a thaw refreeze. And the court said, his decision was made in good faith, supported by the prevailing weather conditions known to him, and it was reasonable for him to exercise his discretion. We're not going to second guess him, even though, in hindsight, there was ice on the road. Nonetheless, his decision at the time he made it was reasonable and had a logical basis. So case dismissed, even though the injured party says, wait a minute, but it didn't work because there was ice on the road. Well, he had a reasonable plan to deal with it. The court wasn't going to second guess it. Remember, ice on the road doesn't get you home. Ice on the road doesn't win you the case. You got to show something. Now, the Hart case is interesting. It started out as a fairly typical case. Vehicle encounters patch of ice, loses control. Okay. And the court dismissed the case on notice grounds. We talked about notice previously. Well, this is the case where notice came to the state's defense. The court didn't have enough prior notice of the icy condition. And even though the state did get notice, actually, they had a police officer call it in. The state reasonably responded. And once they got the call, they dispatched a truck to the accident scene. And actually, in this case, the truck would have been at the accident scene like 30 seconds before the accident. And the court said, they dispatched the truck right away. It took them a while to get there. While he was getting there, he was treating the highway that he was traveling over. And so, there was nothing unreasonable about the state's response. So even though the state knew there was ice because somebody called in, the state has afforded a quote-unquote reasonable time to respond to the condition, and the court said, you responded reasonably. You didn't wait around 2 hours and then dispatch the truck. You dispatched the truck right away. It just didn't happen to get there. But the important part about this case here is something the court said in passing. And this is what the court said, and it was quoting testimony, but this is how it came out in the court's written decision. This is what's in quotes is from the court's decision. And if you see my appendix, you can get the whole decision to give you a flavor. DOT's decision to stall for sand is not based solely on temperature, but is also based on environmental considerations. Wow. That's the only time I've seen the court mention environmental considerations as playing a role. Now, you can't read too much into this because in the context of this case, there was trial testimony from a DOT highway maintenance supervisor, and I got the trial testimony, it's in the appendix, the exact testimony at trial. And he said, quote, he has environmental concerns, and we have an environmental officer on salt usage, and then he went out to say that he bases his decision on environmental concerns. So that's why the court made a statement, because it was that trial testimony in the record before the court. So I didn't want to read too much into the case, because the court wasn't exactly saying that you must take environmental concerns into account. But the court was saying that if DOT says an environmental concern motivated his snow and ice control practices, that's a legitimate concern to take into account. That's the takeaway that comes from the case. And what? Speed it up?
We have a wrap-up.
Well, as far as environmental concerns, the only DOT snow and ice control guidelines does have one section that sort of speaks about environmental concerns, but it deals with traces. This is the section. There's not a similar statement with respect to the actual use of salt. Okay, well, I got to speed it up, so I'm going to speed it up. The second part is written notice laws. The legislature can change any of these court rules that we've been talking about. They can pass a law and change these rules. And they have changed these rules for municipalities in one sense. They passed these laws called written notice laws, which say, the courts say you need actual or constructive notice as a precondition to sue. Well, guess what? We are going to eliminate that rule and say you can't sue a municipality for the presence of snow or ice on a highway unless a written document is received by the municipality telling them they have a dangerous snow or ice condition in a particular location. And as you might expect, in upstate New York, nobody calls you up. Well, first of all, nobody's going to write you a letter. I mean, they may call you up, but nobody's going to write you a letter that says, hey, there's a patch of ice in front of my house. The patch will be gone by the time you get the letter. So nobody does that. So in effect, written notice is never received. And without written notice, you can't sue the municipality. And so municipalities never get sued for these things because they never get the written notice. They don't have to prove that they reasonably maintain the highway. They don't have to prove when their trucks were out and how frequently and how often. All they have to do is get an affidavit from typically the village clerk or the town clerk that says, hey, we never got the notice. Case dismissed. It's over. And these laws are so strong that injured parties' lawyers won't even take the cases because they say, why should I take this case and waste my time? I'm not going anywhere. I work on a contingent fee. I'm going to get paid if I get money from my client. Why should I spend all the time on this case and eventually not on the lose? So the cases don't even take it. We won't get into the history of why they did it. We're short on time. But the point in here is that the state legislature has not done this for the state. You can ask me why. I'll tell you I don't know why. In the Q&A, I don't know why. There's never been any legislative history. Could this state do it? Of course they could do it. They could even limit it to state highways within the Adirondack Park. They don't have to say every state highway in the state. They could limit application to the Adirondack Park highways, and that would be the end of it. The end result is the state never could be sued for a decision to use less salt, because a decision to use less salt is a failure to act in a certain way. These written notice laws cover failures to do more. Failures to do more. Failures to do more salting, failures to do more plowing. the only exception is if the municipality creates the dangerous condition by something it does. But that doesn't apply to a decision to use less salt. So that's it. I guess I better use some time for questions. So why don't I end it here? I see a hand is up, so why don't we take questions from here? Yes,
So,
sir.
is that going to fall apart with email now? You got the
No, it's not going to fall apart. People still don't need it.
That's what it's about notice.
Yeah.
Is it notice of the highway or is it also notice of weather conditions? For instance, now with technology, is DOT going to be more liable because they're notice of the storm?
No. I think there was one slide that said a general awareness that there is inclement weather is not noticed at a particular highway at a particular point as ice. So no. Technology that gives you better weather forecasting doesn't play into this. You have to have notice of ice at a location rather than a general awareness that things are wow. Yeah.
Does contributory negligence take part in New York State?
Yes.
And does, if you alter the natural condition, like you would your sidewalk in front of your house, or we plow sidewalks, for instance, does that increase your exposure?
Only if you, you're getting into a little complicated here. The answer could be yes, if you plow sidewalks and create snowbanks that deprive a pedestrian of access to a crosswalk in an intersection, and he has to climb over the snowbank to get to the crosswalk and he falls, yes. But remember, in a highway setting, that's not going to apply. And we're talking about highways. Yeah.
I think the answer to why we're not going to see a prior written notice statute protecting New York State is that the Plains Bar, and I used to be a member of the Plains Bar, has such control over the assembly that you just are not going to see tort reform of that type in any foreseeable
That's why I said it could be limited to the Adirondack Park. It might not get the kind of opposition you're talking about, but that's beyond my pay grade.
In proving due diligence, you, as a fellow lawyer, can tell you that documentation is always great, contemporaneous. Do you know of any, just as a practical thing for people here who are dealing with highways, do you know of any good set of documentation? I haven't seen the appendix to your thing, but do you know just forms? You mentioned the forms for showing that the trucks went out. You might have other forms that show, where the engineer says, refers to the conditions and doesn't require as much salt, or the temperature is wrong, too low. Is there any kind of thing that people could go to lawyers and others to anticipating litigation that can put them in a better position?
One source I could suggest is Cornell Local Roads Program. Have a whole set of snow planning and documentation, blank documents and templates and those kinds of things. You might want to look, see what they have there.
Yeah, that's true. We're in state DOT. They've got, right, Mike? You got snow ice control tickets, you call them, right? Yeah. Is that a standard form? That's a standard form? Yeah. I mean, there's no magic to the form. They're out there.
You presented 4 or 5 or 6 cases where the court ruled in favor of the state. Is that representative of the incidence of dismissals against plaintiffs? What incidence of successful plaintiffs?
It's very unusual for a plaintiff to win against the state on a snow and ice case. The cases that I found are where a supervisor actually knew there was ice and frankly did nothing. The supervisor denied it, but 3 citizens were very credible to the court and said, no, the ice was there. The court said, I believe the citizens, I don't believe this guy. And so you didn't do anything to respond to the incident, what you actually should have known about. But it's rare. It's a rare case. I'd say 9 times out of 10. Yeah.
Does the law itself consider the severity, like if 5 people died, or sort of 9 cars in the accident, is that?
No, they're not, no. It's not legally relevant, I can't tell you that it doesn't try the heartstrings of the judge, but it's not legally relevant. You know, with the jury.
One more, please.
Okay.
Liability concerns is often held up as a reason not to use less salt. Because they don't want to use the municipality or whoever is managing the roads will not want to cut back on salt because they're concerned about exposure and liability. It sounds like from what you've described, as long as it's part of a professional, organized management practice, that they're confident will still keep the roads safe. That's not really.
Yeah, well, for the municipalities, they're protected by written notice. For the state, I think they have to have some justification for departing, but if they have some logical justification, for example, isn't in the pilot program, didn't you mount rubberized blades? No. Oh, I'm going to try. Okay, so see, that might be the quid pro quo. Well, we reduced the salt, but we did something extra to alleviate these rubberized blades under the body. And of course, okay, they have a reason for what you did. But remember, the presence of ice alone doesn't prove the case. You have to show there was a lack of diligence in maintaining the road. That's what you always come back to. So, maybe you increase your plowing frequency. Maybe you have a supervisor checking more frequently for ice conditions. Those ought to be part of the plan to show the court. We not only reduce the use of salt, we put measures in place to sort of guard against the recurrence of types of presence of ice.
Thank you, Jim.